I've created this site to address the issue of illegal drug laws in Canada, and make public my future plans to sell drugs on Parliament Hill. The reason I'm planning to do such a seemingly crazy thing, is to bring attention to this issue and make public some information that all Canadians should know about, which is new proof I've found, and have tested in court, showing that the limits drug laws place on our rights and freedoms do in fact violate our Constitution. Most people likely know that the war on drugs started almost 50 years ago, and has not only failed to solve any of the problems caused by drug addiction, but has even created countless additional problems that did not exist before. However, few people likely realize that drug prohibition in Canada actually started with the Opium Act of 1908. If almost 50 years of a failed war on drugs isn't enough to show a criminalized approach towards drugs does not work, then consider for a moment that opiate addiction is worse now than it ever has been, and opiate laws have been around for well over 100 years. In addition to failing to solve any of the problems caused by drug addiction, drug laws in our comfortable first world country have had such unintended consequences as causing wars in third world countries. Our drug laws are even contributing to the continued loss of the rainforests, as drug cartels continue to burn huge swaths of forest, just to grow coca plants, whenever the local government finds one of their existing plantations. It doesn't matter if you do drugs or not, this is a global issue that negatively affects us all, and it cannot continue to be ignored. The story relating to how I ended up successfully using this new evidence in court, proving that drug laws are unconstitutional, spans many years, and is too long to share here. I hope you'll forgive the shameless plug, but if you'd like to know more, the full story, as well as many others from my rather eventful life, can be found in my book, Morally Grey: Confessions of a Career Drug Dealer. See the link below for more details. The following is a quick summary. I started studying the Charter of Rights when I was 17, while spending 10 months in jail for stealing, which I obviously deserved to be in jail for. With nothing but time on my hands, I spent countless hours reading the Charter again and again, until I felt like I fully understood it. With that understanding in mind, by the time I was 20, I had found a new way to challenge drug laws that has never been attempted before. I started selling weed when I was 18, about 8 months after I got out of jail. At first, it was just a way to smoke weed for free, but after I moved to Ottawa and started school for engineering, it turned into a way to make a bit of extra money on the side. Eventually I started selling other things I'd sometimes do as well, because it's always easier to get good quality drugs when buying a larger amount. Ultimately, I'd end up selling drugs for almost 20 years. One day, about 7 years ago, I got caught and was charged with 5 counts of trafficking. I had to admit to the police that the bag was mine, so that my friend didn't get charged as well. After I admitted the bag of drugs was mine, they had a legal right to search my car. In the car, they found a notepad with half a month's of day-to-day transactions. So from a traditional sense, it was an open and shut drug trafficking case. However, as I had always said I would, I fought the charges using the Charter in the new way I had discovered when I was a teenager. Representing myself in court seemed like the logical thing to do, because how could I trust this to a lawyer, when they didn't find this new way to fight drug laws? Even though I already knew drug laws had never been challenged under Section 1 of the Charter, within a couple of months after being arrested, as I was researching the proper way to present this argument in court, I discovered something even more significant. Not only have drug laws never been challenged under Section 1, but Section 1 has never been used defensively, ever. The reason why this is so significant is because Section 1 is supreme law in Canada. All other law must conform to it. I'm not going to explain the details of the law in this video, because I explain that in the next 6-minute video. It's not complicated, and you should be able to understand it, even if you don't have a high school diploma. Whenever someone pleads not guilty in court, before a trial date is set, there will always be at least one off-the-record, pre-trial hearing between the judge, the prosecutor and the defense, in order to discuss issues relating to the trial. Since I knew I would be found guilty at trial if the charter motion failed, there was nothing I needed to discuss about the trial, so during that pre-trial hearing, I simply told them, if the charter motion fails, I expect to be found guilty at trial. After saying that, it basically ended the hearing, since there was nothing left to discuss. However, there was still 45 minutes left of court time booked, and the prosecutor and judge knew I was going to file a charter motion under Section 1, and since no one had ever done that, they were obviously curious. So the judge asked if I had the motion with me, and I did, so I ended up giving him and the federal prosecutor an off-the-record copy of it, months before I would have needed to officially submit it. 2 months later, after I admitted to drug dealing, I went to court again for another pre-trial, and the federal prosecutor said, after multiple conversations, with many people in my office, we've decided to stay the charges against the accused. So after admitting to drug dealing, and showing them my entire defense, he dropped the charges, and didn't even say why. When I got home, I told my roommate what had happened. At the time, he was taking law at Ottawa U, and when he told his classes about what I had done under Section 1, not only did it cause a big debate in each of his classes, but 2 of his professors wanted to meet me. One of them was one of the 7 Supreme Court judges. Over the following few years, I would eventually find out that a lot of people in the legal community heard of what I had done. The lawyer who ended up telling me this was a customer who would occasionally buy cocaine from me. Fundamentally, what I understood from what happened was that I essentially had a license to sell drugs. The charges were dropped near the end of February of 2013. Over the next few months, after the initial excitement had worn off, I realized I was actually a bit disappointed and bothered that they dropped the charges, without letting it go to an official hearing. I started feeling as though it would be selfish of me to do nothing at all, being very aware of the global harm drug laws are causing, if I simply kept this important secret to myself, only as my personal get-out-of-jail-free card. By the summer of that year, I had decided I needed to make this public. My plan was to enjoy the summer, and then get to work in the fall, but an unexpected thing happened in August, when I was presented with an opportunity to buy the only after-hours club in the area, which is a whole other interesting story, but that is the reason I'm only going public with this now. The first of the next 4 videos is about 6 minutes long, and explains the entire legal argument in a simple and easy-to-understand way. Each of the other 3 videos include some examples of the evidence I have supporting the legal argument, and only include about 10% of the total evidence I have collected. All of the information in the next 4 videos is also on the website, but the website contains a lot more information as well, including downloads of all case files, as well as complete instructions on how to defend against trafficking charges just as I did. Legal disclaimer. I'm not a lawyer, and I'm not providing legal advice. If you use any of the material I've provided, I'm not responsible for what happens. Follow me on Twitter or Facebook to be notified of when I will be selling drugs on Parliament Hill. Your support is greatly appreciated.